Now live is Stephen Caliendo. He is the Dean of the College of Arts and Sciences and Political Science Professor at North Central College. Thank you for being here. Let's first talk about the timing of this, because so many people in the pandemic have lost their health insurance and, according to the numbers, have really turned to the Affordable Care Act for coverage.
That's right. And so the optics are bad in terms of being in the midst of a global pandemic. But what happened was that the United States federal government joined a case that was moving through from some of the states. I think it's a case from Texas. And so the timing was somewhat out of the control of the Trump administration. But this is a campaign promise from 2016 to overturn the Affordable Care Act, and since we're in the midst of a presidential campaign, a re-election campaign, I think there's a lot of political utility for the president moving at this moment.
What is the likelihood, do you think, that the court will look at this before, say, November?
Well, they could look at it before November. The court generally will come back into session and start to hear oral arguments in October. So it is possible that the case gets heard then, which puts it back in the news. I don't know if that's necessarily a good thing for President Trump or for Vice President Biden, his challenger, of course. Certainly there will be no decision on the case before the November elections happen.
So the filing is based on the elimination of fees. Explain how that could potentially impact the entire act.
Yeah, I mean, so the Affordable Care Act was premised on this notion that if you want to have a system where health insurers cannot deny people coverage because they have an existing condition, the only way to really do that is to make sure that everyone has coverage. Otherwise, people will just wait until they get sick and then buy health insurance. And certainly the insurance industry cannot survive if the only people they're covering are sick people. That is, they're paying out and only collecting premiums from sick people. The system works if you think it works. I think there's good critics that say it doesn't work very well, but it works in a business model because healthy people pay into it and don't get benefits from it, don't take benefits from it because they're not sick. So if you're going to restrict companies from denying people on pre-existing conditions, you sort of have to make sure everybody has to have it, otherwise the system falls apart.
So if this is invalidated, what option would people have who are on it?
Well, if it goes away, then that particular element of health insurance goes away. People that are still getting health insurance through their employers or who have bought it independently, it wouldn't affect them at all. The challenge has been all along for Republicans who haven't liked this bill to replace it with something else. And in the first 2 years of the Trump administration, when they controlled both houses of Congress, we would think that they would have figured out a way to do that, but they haven't been able to agree on exactly what should replace Obamacare. There is bipartisan support for making sure that companies cannot deny on pre-existing conditions. So that's a good start. How we get there is another question.
Right, because of that, no matter what side of the aisle you are on, you realize that the pre-existing condition factor is something that is so critical. What do you think the chances are that we see some of this act remain just for that reason alone?
Yeah, or some new healthcare bill that has that provision in it. Again, I think if it was an easy solution, that somebody smart would have come up with it by now, and we really haven't seen very much of that. So, it's possible also that the court hears it and says, this is a constitutionally sound piece of legislation, and it can stand even without this mandate. It also could be that if the election goes a different way in November, and the Democrats pick up some seats in the Senate, that maybe they bring the mandate back, for instance. I mean, it's a public policy decision, and so there's a lot to still be decided.
Let's shift gears, Doctor, if we can, and talk about the other court ruling, which said that the law that limiting the role that federal courts play in the asylum process. This was another big issue. Tell us what the takeaway from that has been.
Yeah, the takeaway from that is that the idea was that they could fast track asylum seekers back out of the country. And folks who were arguing on the other side were saying that it shouldn't be an executive decision to move asylum seekers back out or to push them away, but rather they ought to have the right to a hearing in a federal court about whether or not their case met the benchmarks for seeking asylum in the United States. And so this was a very interesting decision because, unlike what we saw in recent high-profile decisions with close calls. We saw a 6-3 decision and a 5-4 decision last week that went against the administration. This one not only went for the administration, but it did so 7-2. So the two Clinton nominees, Justice Breyer and Justice Ginsburg, sided with Chief Justice Roberts and the 4 reliable conservatives on overturning this or on supporting the law that made the hearing not have to have a hearing. Excuse me.
Stephen Caliendo, thank you so much.
It's great to be with you. Thank you.